Hey there, I'm the MadCatster. Am I glad to see you here? Well, Ashley Gillard, the TikTok psychic, we had talked about how she had filed another motion with the court. It was for reconsideration of the granting of the partial summary judgment. She's been beating a dead horse, as we've talked about. Well, the judge has smacked her down in this latest episode. You know me, I've got the deets and all the receipts, so buckle up and let's go. So I'm here with Sybil the Enforcer, and she is purring away as always, and she's hanging in there, my old girl. She's gotten a little skinny, so I've been putting supplements in her food. But before we get started, I do want to say one thing. I want to say a very special thank you to somebody. I had a delivery come from the Amazon wish list, and I put the box aside thinking it was household stuff I had ordered, and totally forgot to go back and open it. And this past week, when I was arranging some stuff in my entryway, I saw the box sitting there and I said, "Oh, what is that?" And I opened it up and there was stuff in it, and I feel so terrible. A very special thank you to the notorious CAT for sending us a bunch of goodies. They sent us a bunch of treats, and they also sent us a nice warm round cat bed, and they sent us some cat litter, things that we absolutely need, absolutely appreciate. So the notorious CAT, thank you so much. Please forgive me. I totally forgot to go back and open that box, and I feel so bad, but thank you so much. We really, really appreciate you and everyone that sends stuff from the Amazon wish list. But anyways, let's talk about Miss Ashley Gillard, the TikTok psychic. So yes, I still have not put up the video where I respond to her trashing me because all these other things keep coming up, and I've got actually another video that I'm making to come out hopefully over the weekend. There's been developments in the Sniper Wolf nasty, nasty divorce and lawsuit. And you're not going to believe the stuff that I've got for you in that one. So check for that video coming up in a few days. But Ashley Gillard has been going back and forth with the judge, trying every avenue to try to get the court to rule differently because she's not happy with any of the rulings that have come down, obviously, because she's lost all of them. And at this point, you know, the judge, I think, has given her a final smackdown with regards to this reconsideration stuff about the motion for summary judgment. So let's take a look. It's not a very long court ruling, so we're just going to quickly go through it. Let's take a look. I'd like to thank today's sponsor, Mint Mobile. Mint Mobile is challenging wireless industry norms. They've done away with a lot of the nonsense. There are no monthly bills. You don't overpay for features that you don't need. No BS, just premium service starting at $15 a month. One of the things I love about Mint Mobile is how they've changed the wireless shopping experience so that it's all online. You don't have any stores to deal with, any staff to deal with, nobody pressuring you. You can sit at your own leisure and go through their plans and their features and their equipment. And like I said, with Mint, there are no monthly bills. It's bulk buying, so you buy everything up front, and the more you buy, the more you save. So they have 3, 6, and 12-month plans. And with Mint, you choose how much data you want. You're not stuck with a one-size-fits-all price in your plan. They start with 5, 15, 20 megabytes a month or unlimited, depending on what you think you're going to need and how much data you're going to use each month. Also, their plans include some really cool features like free calling to Mexico and Canada, and also, believe it or not, to the United Kingdom. Plus, there's also included hotspot service, so you have a 10 megabyte hotspot service with the unlimited plan. And they have the nation's largest 5G network. They provide 5G coverage to 98% of Americans and 4G LTE service to 99% of Americans. And you can bring your own phone if you want, or you can shop for new equipment on Mint's site, whichever you choose. But whichever option you pick, you get to keep your own phone number and all of your contacts. And Mint makes it really easy to switch. A lot of people have this misconception that it's going to be hard to switch. It's not. Mint makes it very easy. You can be up and activated within minutes from the comfort of your own home using an eSIM. And if you have any issues, Mint has excellent customer care, and 96% of Mint's customers rank themselves as highly satisfied with Mint's customer care. And to top it all off, all of their plans come with an unconditional 7-day money-back guarantee. I think Mint's great. I think you should check it out because I think you'll think it's great too. You can use this QR code that I'm putting on the screen here. It'll also be down in the description. And I really appreciate you checking out my sponsors. So thank you, Mint, for sponsoring this video. It's the memorandum and decision regarding defendant's Rule 60b2 motion for reconsideration of partial summary judgment. The court says pending before the court is defendant's motion for reconsideration of partial summary judgment. Because the court conclusively finds that the decisional process would not be significantly aided by oral argument, the motion will be cited on the record and without oral argument. As discussed more fully below, the motion is denied. So the judge is saying, she definitely doesn't want them to come in and start making oral arguments and drag this out any longer. So she feels there's enough on the record, which clearly there is. There's so much stuff on the record now that she doesn't need oral argument to make a decision. And so she says, the case, as you know, arises out of the tragic murder of 4 University of Idaho students in November 2022. Plaintiff Rebecca Schofield is a professor at the University of Idaho. She alleges that despite never meeting any of these students or being involved with their deaths in any way, Ashley Gillard posted numerous TikTok and later YouTube videos falsely claiming that plaintiff had an extramarital romantic affair with one of the victims, then ordered the 4 murders to prevent the affair from coming to light. She said that plaintiff sent cease and desist letters to the defendant, which we know, in the following days and weeks, and the defendant did not stop. Plaintiff initiated this action. And if you remember, there's a very infamous, I think it was a TikTok where Ashley Gillard is basically insinuating that she's going to wipe her bottom with the lawsuit. So clearly she has not had any respect for the court or the suit at any point in this process. It says, when defendant did not stop, plaintiff initiated this action. Plaintiff asserts 2 defamation claims against defendant. One is premised upon the false statements regarding plaintiff's involvement, the murders themselves, and the other is premised upon the false statements regarding plaintiff's relationship with one of the murdered students. On June 6, 2024, the court granted plaintiff's amended motion for partial summary judgment on the issue of liability for plaintiff's 2 defamation claims against defendant. The court concluded that plaintiff sufficiently demonstrated the absence of any genuine issue of material fact relating to the falsity of defendant's statements about her. And then we can skip this part. But under Rule 56, this shifted the burden to defendant to dispute that claim by setting forth facts showing that there is a genuine issue for trial relating to whether her statements about plaintiff are true. In relying only on her spiritual investigation into the murders, however, the court concluded that defendant did not satisfy her burden. And I incorrectly stated in I think it was the last video I made, that, not incorrectly, but I should clarify. I said that it's up to Ashley Gillard to prove that the statements are true. That's not the case in most defamation cases. It is up to the plaintiff to prove that the statements are false, but there's a special situation in Idaho and the court is not completely settled on whose burden it is. And so basically what the court had said was, under the precedent and the laws and rulings in Idaho, the burden did shift to Ashley Gillard to prove that the statements were true and not the plaintiff's. And so under that particular situation, that's why it became Ashley Gillard's burden to prove that the statements were true. As a result, defendant's psychic intuition without more cannot establish a genuine dispute of material fact to oppose plaintiff's summary judgment efforts. The court therefore concluded that the totality of the evidence reveals that there is no genuine dispute as to any material fact that defendant defamed plaintiff. Also on June 6, 2024, the court granted plaintiff's motion for leave to amend complaint to add punitive damages. In permitting a claim for punitive damages, the court concluded that plaintiff established a reasonable likelihood of proving by clear and convincing evidence that defendant's conduct in accusing plaintiff of an affair with a student before ordering that student's and 3 other students' deaths was oppressive, fraudulent, malicious, and or outrageous. I agree. I think we all agree. To the extent of plaintiff's damages, if any, remains an issue for trial. And as we've talked about, the only thing left now to go to trial is the issue of damages. Like, if they're going to be damaged, how much are the damages going to be that'll get awarded to the professor? I'm sure there will be damages, but we still have to wait and see about that. Defendant then moved for reconsideration, alteration, or amendment of the court's June 6, 2024 memorandum of decision pursuant to 59C. Defendant specifically argued that the decision was based upon a manifest error of law or fact and should be amended to prevent manifest injustice and impediment to justice due to the lack of judicial impartiality, which is nonsense. It drives me crazy when people, when they appeal, it's not because of an actual fact or an issue of law, but they just claim judicial bias. I mean, it's the lamest reason you can have for appealing something or for asking for reconsideration, because it's extremely rare that you can actually show that there was any bias on the part of the court. As much as maligned as our courts have been recently, they are, for the most part, impartial and erroneously allows for excessive damages. These reasons, according to defendant, warranted the wholesale dismissal of the case under the rules. The court disagreed and denied defendant's motion. In response to defendant's particular arguments, concluding that the decision did not violate the First Amendment, the court has subject matter jurisdiction, properly resolved plaintiff's defamation claims, and has not violated defendant's right to a fair tribunal. Idaho law permits a claim for punitive damages, and defendant's defamatory statements are not privileged. Now, via the pending motion, defendant again. And Ashley Gillard took exception with the fact that I kept saying she keeps trying to have another bite at the apple. And in fact, I mean, the court's even saying it right here. Again moves the court to reconsider its decision, this time pursuant to Rule 60B. Defendant claims that newly discovered evidence in the form of filings in a related state court criminal proceeding provides factual support that substantiates the TikTok videos defendant posted regarding the murder of 4 University of Idaho students. Defendant maintains that she cannot be found liable for defamation because the newly discovered evidence proves that she was telling the truth in these TikTok videos, or otherwise highlights outstanding issues of material fact that preclude summary judgment. Plaintiff again opposes defendant's latest motion in its entirety. These arguments are considered below. Okay, so now the legal standard. Under 60B, a court may relieve a party from a final judgment, order, or proceeding for the following reasons: mistake, inadvertence, surprise, or excusable neglect, newly discovered evidence that with reasonable diligence could not have been discovered previously, fraud, misrepresentation, or misconduct by an opposing party, the judgment is void, the judgment has been satisfied, released, or discharged, or any other reasons that justifies relief. The Rule 60B is an extraordinary remedy and is granted only in exceptional circumstances. The moving party bears the burden of proving the existence of a justification for Rule 60B relief. Here, defendant relies on Rule 60B2 when she claims that newly discovered evidence exists that corroborates the truth and accuracy of her statements about plaintiff's involvement in the November 2022 murders. Relief from an order on the basis of newly discovered evidence is warranted if the moving party can show the evidence relied on in fact constitutes newly discovered evidence within the meaning of Rule 60B. The moving party exercised due diligence to discover the evidence, and the newly discovered evidence must be of such magnitude that production of it earlier would have been likely to change the disposition of the case. The disposition of a Rule 60B motion is committed to the sound discretion of the district court. And now she's going to discuss why the courts decided not to grant this motion. Defendant argues that newly discovered evidence revealed in a parallel criminal proceeding in state court tracks statements made in her earlier TikTok videos about various circumstances surrounding the murders. For example, defendant claims the newly discovered evidence confirms her statements about how the surviving roommates were afraid the night of the murders, a dog being in the house at the time of the murders, a breakup involving one of the victims and her boyfriend, the 4 victims being located in 2 different rooms, and the imminence of an arrest. From this, defendant contends that the perceived synergy between her psychic intuition and the newly discovered evidence not only validates her separate statements about plaintiff's role in the murders and relationship with one of the victims, but also highlights how her theories about the murders have never been proven false, and therefore her absolute defense of truth against plaintiff's defamation claims remains plausible. Plaintiff counters that defendant's arguments are procedurally improper because the June 6th decision is not final judgment. The plaintiff additionally argues that the evidence defendant cites is not admissible and regardless does not affect the court's analysis. Plaintiff lastly questions defendant's diligence, arguing that she was already aware of most of the evidence she now relies upon in her motion, i.e. the evidence is not new at all, but did nothing to formally obtain it during discovery or otherwise make any effort to incorporate into her summary judgment briefing. The court agrees with plaintiff. And Ashley Gillard kept saying that, there's more evidence coming to light. And she had questioned my saying that, no, there isn't any new evidence coming forth. What she was referring to is evidence that has been not released to the public or that has not been actually brought up in trial yet, but that does already exist and is in the custody of the prosecution and the police, so that both sides should be aware in the criminal case of what they actually have, even if it's not been made public yet. And Ashley Gillard seems to think that, because it hasn't been made public, somehow it's new evidence, but it's not. Even assuming the defendant's reconsideration efforts are procedurally proper and that the referenced evidence is both newly discovered and admissible, defendant's motion suffers from a fatal flaw. The evidence does not change the disposition of the case. What Ashley Gillard was trying to say is, look, see, I predicted that right, or I saw that right in my psychic investigation. Therefore, everything I'm telling you is true about what happened. And that's just not how it works. Defendant's motion suffers from a fatal flaw. The evidence does not change the disposition of the case. Absolutely nothing about the evidence suggests that defendant's statements about plaintiff is true. That certain of defendant's psychic insights may have randomly coincided with banal aspects of notorious and well-publicized murders is hardly surprising, but this happenstance alone does not legitimize defendant's perceived clairvoyance, nor can it bridge the gap between defendant's intuition and the truth, a crucial aspect of plaintiff's defamation claims against defendant. Ultimately, the cited evidence is wholly unrelated to plaintiff. If anything, it underscores that there continues to be no evidence that plaintiff had an affair with the student or orchestrated the murders to keep that affair secret. And she got all huffy about the fact that I kept saying that there's nothing that shows that the professor is in any way involved. And she keeps saying, oh, there's new evidence coming forward. And somehow she thinks this like smoking gun or this Perry Mason moment's going to happen. And aha, the professor did do it. It's just ridiculous because there's absolutely nothing, not even a shred of evidence that would show that she's even remotely correct. The defendant's insistence about how her theories surrounding the murders have never been proven false is likewise unavailing. She claims that evidence pertaining to 3 sets of DNA under MM's fingernails, the victim's defensive wounds, and blood at the crime scene from 2 unidentified males is not inconsistent with her underlying theory that plaintiff orchestrated the murders and framed Brian Kohberger, the defendant in the state criminal action, by planting a knife sheath at the crime scene. And they'd gotten evidence off the knife sheath that connected him to the scene of the crime. And Ashley Gillard keeps insisting that that's irrelevant or meaningless, but, whatever. But this misses the point. As the court already stated, this case is not about whether Mr. Kohberger committed the murders. Though the court's consideration of those issues may have touched upon a matter of criminal concern in a parallel criminal proceeding in state court, the court never endeavored to apply the elements of murder and adjudge plaintiff innocent and Mr. Kohberger guilty. Rather, this case is about whether defendant defamed plaintiff by repeatedly accusing plaintiff of an affair with a student before ordering the students and 3 other students' murders. On that linchpin point, the court concluded that there is no genuine dispute as to any material of fact that defendant did so, regardless of whether Mr. Kohberger or anyone else committed the murders. The evidence that defendant cites in support of her motion does not change this conclusion because there continues to be no corroborating support for defendant's statements about plaintiff. For these reasons, defendant's motion is denied. Based on the foregoing, it's hereby ordered that defendant's motion for reconsideration of partial summary judgment is denied. The parties shall meet and confer to discuss trial dates. After doing so, on or before June 16, 2025, the parties shall file a joint status report with the parties' proposals for trial dates and whether the parties have a mutual interest in participating in a judicial settlement conference. Based on the way Ashley Gillard has conducted herself throughout this whole mess, she's not going to be interested in any kind of settlement conference. And actually, if I were the professor, I wouldn't be either, because I think this has gone on so long and there's been so much damage and there's been absolutely no sign that Ashley Gillard is about to back away from anything she said, that it needs to go to trial over damages. And I think the jury needs to hit her, even if the professor can never collect a dime. I think it's worthwhile to see this thing through to conclusion, just to make an example of the TikTok psychic, because it's absolutely absurd and egregious what's happened. Let me know what you think down below. I'd be Interested to hear what you think at this point in this case that we've covered for so long. Let me know your thoughts. Like I said, look out for my video about some interesting and really shocking things that have come to light in the Sniper Wolf case. You're going to want to see that video because you're not going to believe the stuff that I've got to show you. Anyways, you guys, in the interim, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.